You understand that you're charged with the following offenses. Cruelty to children, count 1, cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. And count 2, cruelty to children in the first degree, which also carries a sentence range of 1 to 10 years.
What did we decide? We actually decided to take a plea deal.
I understand. I'm asking, do you understand? I'm
Do I-
explaining to you the.
Yes, I do.
Yeah, and the question, Ms. Smart, is just, this is what you're charged with.
Okay.
And the sentencing range is the 1 to 10, not that that's what anyone has agreed to. That's just what the law is.
I'm so sorry.
That's okay. This is not something you do often.
Would you like me? I'll restate that question.
Thank you so much.
No problem. Do you understand that you're charged with the following offenses? Count 1, cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. And count 2, cruelty to children in the first degree, which also carries a sentence range of 1 to 10 years. Do you understand? That those are the sentencing ranges, not what you're pleading to today.
Yes, sir.
Okay.
Deputy Gordon.
Yes.
Sorry to interrupt.
May I have one
Quick
more
pause. Is Mr. Stone here?
Yeah, the right.
He will be here? He's in transport?
Yes.
Okay, thank you.
Okay, so that's what that said. That's what the statute said.
All right, back to what we need to do.
Thank you.
Keep going, we're good.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with their services?
Yes.
Counsel, do you waive formal reading of the indictment?
So waive.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes, we waive.
Ms. Smart, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of 10 years probation, that you shall complete mental health evaluation and any recommended treatment, that you shall consume no illegal drugs or alcohol, that you shall have no contact with the victim, Amira Henderson, Amirah, Henderson, Henderson. Do you understand that? And that, go ahead.
It is upon request of the daughter and supervision if needed.
Yes, except upon, I'll say, written request of Miss Amira Henderson and supervision if required.
Oh, no, we hadn't discussed those terms. We had discussed a different term in the hallway.
Do you need a second to talk to your
Yes.
attorney?
Can I have 1 second?
Sure.
Okay.
That's what he just said.
What do you understand?
Judge, while they're doing that, I have the SC number if you need.
Remind me which case this goes to?
The behaviors in the day.
Is this the Aaron Pendleton? No. I'm looking for Ms. Williams's cases and I'll give you names. It's not Teresa Smart. We're doing that. Trinice Lawton,
Yes, that's it.
Ms. Wood's case.
Yes.
Okay.
It's 26 SC
Zero,
002 690.
690.
Yes, Judge.
Great. Thank you. Is Ms. Lawton here now? She is. That's right. Okay, great.
Your Honor, if I may, there's some confusion about the behavior and sentence date that I will be requesting.
Okay.
And Ms. Smart is understanding what the state is offering, but I was trying to explain to her that there is a potential upon Your Honor's approval of behavior incentive date.
Sure.
And she wants to, I don't want to skip ahead to that part, but she's not comfortable saying anything about the 10-year probation until we talk about the behavior incentive date. So how can we assist?
Well, a couple things, Ms. Smart. Right now, what Mr. Peeples had put on the record is what I think was negotiated, that the the sentence would be 10 years probation, and then he provided a few of the special conditions that you get an evaluation, if any treatment is recommended, you follow that treatment, and then no contact with Ms. Henderson unless she asked for it, and if so, that would be supervised contact. That's as far as we got.
Yes.
There are any other conditions?
No, Judge.
Okay, so that's what the state's going to be recommending. Ms. Sherry Lassiter is going to be asking that I set a behavioral incentive date. How many years out were you asking?
We're asking for 1 year, Honor, because the case is 2 years old. Normally I would ask for 3, but she's already, no trouble in the past 2 years. She's already been compliant with every law.
Okay, so your lawyer is going to advocate, Ms. Smart, for a behavioral incentive date of about a year from now. And if I agree with that, and I don't know yet if I'm going to agree with it, because I actually don't know anything about the case, then you would be done with probation in a year. I might instead say, I think the behavioral incentive date should be a little further out. I might say 2 years, or something like that. But I am the one who decides. I'll hear from you in just a second. Let me just finish. I am the one who decides whether there's a behavioral incentive date. Your lawyer can't impose that. The prosecutor can't impose that. They can advocate for it, and I'm certainly going to listen to them. Your lawyer knows you best among the people here in the room. Mr. Peeples is particularly close to the facts of the case, and so I will certainly be open to being persuaded by what they have to say. But I can't promise you anything right now because I need to hear more about you and your situation. For example, I didn't realize that the case was quite this old. It looks like its anniversary is two days from today.
Correct. Yeah.
And so if you've been doing all the things you needed to do over the last 2 years, that's a great reason to say, let's have a pretty short behavioral incentive date. But I think you can understand why I'd want to hear all the moving parts before I say, all right, here's how we're going to sort this out. Does that make sense? You got to say out loud, yes.
Yes.
Okay, did you have a question before we keep going?
Yes, sir. My question would then be, since it's been 2 years of me doing parenting classes, mental health, I did community service. I did a lot of things that are going to be remandated in the community service setup. And it's already been 2 years of me not having my daughter. Would we be able to reconvene in a month to make that decision?
Oh, no, we haven't gotten that.
So today's the day we're sorting these things out, because if we don't, then we don't need to wait a whole month. We'll go to Monday, and on Monday we'll have a trial. And we can bring in the doctors and the police officers, et cetera, and they'll tell me what. Yes?
I thought it was your decision.
No, let's get.
So I'm doing a bad job of describing. So if you go forward with the plea, if you accept responsibility for what happened here, then it is my decision as to what we do with the sentence. And I want to set your mind at ease. If both lawyers are recommending probation, I'm very likely to go along with the probation. To me, the question mark will be, where do we set that behavioral incentive date? And that's where I need to learn more about how you've been doing. You've already shared some things. You've done some community service. You've been taking parenting classes. Those are all great steps forward and important for me to hear. But if we don't do the plea today, then the next item on the agenda is trial on Monday, which would mean bringing Amira down here and she testifies and the doctors testify. And that's a decision for you and Ms. Sherry Lassiter to make. Otherwise, we can go forward with the plea and figure out what we're going to do there. Do you have a preference?
I'm not comfortable with the plea,
Tell me what you're not comfortable about.
the 10 years.
Okay. What is it you think should happen?
The 10 years should not be, I mean, I know that that's just like preliminary, but it just seems such a far-fetched number.
Pardon me?
It seems like a way, it just seems like a it just seems like the max, like not the, it just seems,
Yeah.
It seems.
It's a big number.
It's a big number.
It's a big number. It's probation rather than being in custody. But yes,
I'm a nurse, which means that the longer I'm on probation, also without me, and I haven't been working as a nurse for 2 years.
Right.
So this has killed my finances, my livelihood,
okay.
my
Your Honor,
daughter, everything that I've worked my entire life for.
Your
So
Honor.
it's 10 years.
Okay, so let's take a quick pause. I think the lawyers are going to confer for a second.
I didn't.
I mean, I'm fine, but she gonna blow it up.
Yeah, if I may, Miss Smart is saying a lot of my argument right now.
I think so. It's persuasive too.
Yeah, and I had all that she's saying, you're taking my job. I just think that if we can get to that point, present my argument for the behavior incentive date,
Right.
she can have more of a conscious decision about what she wants to do. We haven't gotten there quite yet.
Right.
I think she heard the 10 years on the stand, and even though we talked about that in the hallway, I
Right.
did talk to you about that. And I did talk to her about my request, but the request I'll be making it is your honest decision. I just think that we need to let everything play out. If she could just hold her questions till we get to the end, if possible.
Okay.
And then we decide what you want to do after the judge allow me to present your case to the judge.
Are you all right with that, Ms. Smart, if we go forward with it and then we'll see how it shakes out, okay? Yes?
Yes, sir.
Okay. Mr. Peoples?
Yes, sir.
Yes.
Sorry.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
Yes. Yes, sir. Thank you.
You understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes.
Do you understand that you are not allowed to possess nor use a firearm or any replicas while on probation?
Yes.
Are you a citizen of the United States?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all these rights?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
No, sir.
So, is this a Alford plea or
Yes,
was
it's
this
Alford.
question asked in a way that was confusing?
It'll be an offer plea. It's in her best interest to take the plea.
Got it. So, Ms. Smart, what Mr. Peoples had just asked is, are you prepared to enter a guilty plea? And you said no. But now I understand why. Your plea is going to be what we call a best interest plea, where you're effectively saying, I don't agree with all these things you say happened. However, I, Ms. Smart, would like to put this behind me, and I'm going to go forward with this plea because I've decided after thinking about it, talking about it with my lawyer and others, that it's in my best interest, meaning your best interest, to go forward with the plea. Does that describe your situation?
Yes, sir.
Okay, and that's what you want to do?
Yes, sir.
Okay.
How do you plead to count one, cruelty to children in the first degree?
Alford?
You say what? So there are three things you can say right now. You can plead guilty, but you've told me that's not your plan. You could plead not guilty, which means on Monday we start the trial, or you can say guilty under Alford, which is that best interest plea. So that's how you are signaling to me and the world that yes, I want to work this out. It's best for me, maybe best for my daughter, but I'm not agreeing with everything you say happened.
Okay.
So that's guilty under Alford.
Okay. Guilty under Alford. Thank you.
How do you plead to count two, cruelty to children in the first degree?
Guilty under Alford. Thank you.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
You understand that you have only 12 months from today for misdemeanors and 4 years for felonies to file what is known as a habeas corpus petition, challenging the voluntariness of this guilty plea.
Yes.
You do not have a right to appeal directly from this guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request what is known as a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today's date. Do you understand?
Yes.
You understand any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on or about May 30th to June 4th of 2024, that law enforcement responded to an incident location at Children's Healthcare of Atlanta on Johnson Ferry Road within the bounds of Fulton County. The victim child, Amira Henderson, was brought with neurological concerns and drug ingestion. She was initially transported to Emory-Hillendale by her daycare. Hospital staff alleged that her mother, the defendant, had placed some unknown substance into her IV drip. It was determined that they were benzodiazepine, benzos. She had also given Amira melatonin and Benadryl, and at some point, the defendant had to be removed from the child's hospital room, where she began to improve. Your Honor, the father, I believe, is on the Zoom. My understanding is that he did not want to speak, but he is present. And he is aware of the recommendation. I believe he's fine with it. I did not work out this. I am, as I've informed the court, I am standing in, but the state does believe that this is an appropriate resolution.
Okay. Do you know from your review of the file where Amira Henderson is now? I don't mean physically today, but she is under whose care?
With her father.
Okay. And is that there's a Henderson on the call? That would be the father?
Yes, Judge.
Well, it says Denique. Okay, but most importantly, the daughter is with the dad.
Yes, Judge.
Okay. And that's where she's been, I guess, since this happened.
Yes.
Okay. All right. And how old is the daughter now?
6.
She's
She's
6,
six.
Judge.
Okay. All right. Thank you. Ms. Harvey, do you have criminal history information for Ms. Smart?
Yes, Your Honor. 4 Cycles does not appear to have any prior felony convictions. The last arrest was June 3rd, 2022 out of Clayton County for criminal trespass. She entered a NOLA on that case, Your Honor, and nothing further to add.
Thank you.
You're welcome.
All right. Ms. Sherry Lassiter.
Thank you, Your Honor. Just to go over a little bit what we've heard already, we will be requesting a plea under first offender. She does not have any felonies on her record, as we just heard, and that we be able to seal her record so that she can be able to continue working. She hasn't been able to work in the past 2 years. She has complied with all of the conditions that would be imposed on probation for the past 2 years of her own without a court order. She has been to parenting classes. She's conducted community service. She's had no other criminal involvement in the past 2 years. She also, I don't believe, has seen her daughter since this incident, so she has no contact with the daughter. And the child is now in Savannah with the father, which she's understanding that if she's able to see her, that it will be at the daughter's request and at whatever supervision they deem appropriate at that time. We are asking for a behavior incentive date, Your Honor, of 1 year because she has been going through this for the past 2 years, and she has been technically on probation without a actual order. 43 years old, she's been a nurse over 20 years, and she, because of her nursing background, this situation did not she's taking responsibility. I don't want you to think she's not aware about what happened, but because of her nursing background, she felt that she was helping her daughter. She had no intent to injure her daughter. And she, I believe,
Was there an underlying condition that her daughter had, or?
did have a illness.
Okay,
Bacterial meningitis.
She had bacterial meningitis.
okay,
And I believe the over-the-counter melatonin Benadryl was to assist her with her resting. I'm not sure of the other substance, but she was doing what she felt like, which now she knows it's not appropriate. And I'm trying to make sure I don't leave anything out.
They gave her Ativan at the first hospital,
Okay.
and she was very lethargic.
Okay, yeah, so she had been to, before this hospitalization, she had been to a previous hospital where they were giving her Ativan, which also makes the a child like lethargic or tired acting. So it was an ongoing medical condition, but at this stage, we were trying to get her in the another program, the pretrial program, but because she had the Clayton County trespass issue, which I think was a domestic issue from those years ago, she was not eligible for that program. So that's why we were asking for that 1-year behavior incentive date, Your Honor, if possible.
okay. And just to clear things up, it is Ms. Henderson's stepmother who's on. Her father's at work, so Denique Henderson is stepmom. So she's listening in and representing that part of the family. But Mr. Henderson needed to be at work.
Thank you, Your Honor.
Sure. Ms. Smart, do you have other kids?
I do. They're older though.
What does older mean?
My son is 28. He's U.S. Navy, and my daughter is 23. She's U.S. flight attendant, and my baby girl is 6.
You have a brother who's 6, or you have a 6-year-old?
My baby girl is 6.
Oh, your baby girl, meaning Ms. Henderson, right, got it. Okay, so you have a 28-year-old in the military, 23-year-old working with the airlines, and then we've got the child who's the subject of this case.
Correct, Your Honor.
Got it, okay. And are you based locally now, or are you in Savannah?
No, sir. He got into the military about 8 months ago, so he's U.S. Army now.
Okay, but you, Ms. Smart,
Stone Mountain.
okay,
Stone Mountain.
got it. So you're DeKalb County, you're local.
Yes, sir.
Okay, all right. Tell me why you were doing community service and where you were doing community service.
For an organization called, it wasn't community service, it was paid service. It's basically the only kind of work I can find right now because of my record,
What's the name of the company?
but it's CEO.
CEO is the name of the company. Where is it based? Where is it? Is it?
Well, what kind of work were you doing?
A little pickup, trash pickup,
Okay.
cleaning public restrooms, things
Got it.
like
I'm familiar with the CEO program.
Okay.
We have folks in our accountability courts who use that. The parenting classes, one class, lots of classes. Where'd you go for those?
Most of those are done in, I can print out the certificate for that. You call and Zoom and we do every Wednesday from 2 to 4. They'll walk you through the stages of growth in children about how to react to your child when they get upset.
We can get the certificate sent
I don't need to see them. I just was interested in hearing about them. Ms. Smart, you are asking to be sentenced as a first offender. You qualify for that. It's mostly an opportunity because if I sentence you as a first offender, this is not a conviction. So if you are trying to go back to work as a nurse or go back to school to get an advanced degree, you don't have to check the box that says I'm a felon because you're not. You will be a first offender probationer. So you will have a sentence, but it is not a conviction. That's very, very valuable for a professional like you. But it comes with a risk. If you are not sure you're going to be staying out of trouble in the next few years, losing your first offender status would mean I would be resentencing you. And in this case, it could be up to 20 years. That's what 10 plus 10 is. I'm not saying it would be anything like that, but I just need you to understand the risk of first offender. It is primarily a benefit and one you qualify for. But the risk is if you aren't taking good care of yourself, if it turns out that you would benefit from some treatment and you're not doing that and you get arrested for doing something else, not only would you have that new case, but this old case, the state could say, no more first offender. We want that revoked and please resentence Ms. Smart. And I would think about doing that. So do you understand the risk of first offender
Yes, sir.
and the benefit?
Yes, sir.
And would you like to be sentenced as a first offender?
Yes, sir.
Okay, I'll do that. Ms. Sherry Lassiter, I'll look to you to present an order that would seal Ms. Smart's records. Obviously include Mr. Peeples or Ms. Williams on that email in case they've got an issue with it. But if it's a standard order, they shouldn't have an issue with that.
Look at that over, Your Honor.
All right. Ms. Smart, do you have any questions before we get to the end of this?
No, sir.
Okay. Well, Ms. Smart, I find there's a factual basis for your plea. I understand that it's an Alford plea, that you disagree with some of what the state said. But my review of the record is that if this went to trial, a jury could find you guilty of the charges. I don't know that they would, but if they did, I'd find that there's a sufficient basis for their finding. I also conclude that your plea is knowing and voluntary. You know what voluntary is. That means no one's forcing you to enter the plea. And knowing means you've understood what we've been talking about. Maybe not right away, but after asking questions of your lawyer or of me, I feel like you're in a position that you've understood what we discussed. Do you agree with that?
Yes, sir.
Okay, then I'll accept your plea. Ms. Sherry Lassiter, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Mr. Peeples?
No objection, Judge.
All right, and Ms. Smart, is it all right if we electronically sign your name indicating your Alford first offender plea in this case?
Yes, sir.
We'll do that. Ms. Smart, I am going to sentence you on count 1 to 6 years. Count 2 will be 6 years. I will run those concurrently with each other, and I will probate them. So it's 6 years probation. Special condition of probation number 1 is that you get with a mental health professional, have an evaluation, and if that doctor or counselor recommends any treatment, be it medication or counseling or therapy, that treatment becomes part of your probation. Special condition number 2 is to have no contact with Amira Henderson unless she initiates that contact. So if she reaches out through her father or her stepmother to say, we want to do a FaceTime or this or that or a visit, that's okay. It's just you aren't reaching out to them to check on Amira. You understand those conditions?
Yes.
Okay. Mr. Peeples, did you have any other conditions that I overlooked?
No, Judge.
All right. Ms. Sherry Lassiter, other than the behavioral incentive date, which we're going to talk about in a minute.
No, Your Honor.
All right. So, Ms. Smart, well, let me ask this. Ms. Henderson, if you put it in chat, you can come off mute. I want to confirm that you and your husband and Amira have been able to move forward without Ms. Smart trying to reach out to have contact with Amira. Can you confirm that?
Can you say again one more time, Judge? Good morning, everybody.
Good
Can you
morning.
go again, please?
Good morning. I just wanted to make sure, Ms. Sherry Lassiter has said that Ms. Smart has complied with the condition of bond, which was to have no contact with Amira. And I just wanted to make sure that you and your husband haven't had any issues with Ms. Smart showing up at the house or reaching out, trying to have contact with Amira.
No, she has not done that.
Okay.
She would not initiate to do that.
Okay.
Yes, ma'am.
Thank you.
You're welcome.
All right. So, Ms. Smart, what I'm going to do is set a behavioral incentive date at November 29th of 2020. Make sure I do the math right. 2027. So it's a year and a half from now. If during that time You have continued to have no contact, which you've done great with. And just as importantly, you have demonstrated to probation that if there was treatment that you should be following for your health and well-being, that you're doing that and you're on track with that, then probation is invited to come to me to say, hey, it's been 18 months. Ms. Smart is doing everything she was supposed to do. Can we please close this case out? And if that's what they ask me to do, that's what I'll do. So it really is up to you. If you are doing the things that I know you can do and I know you want to do, then probation will say, we don't need to do the full 6 years. We've established that Ms. Smart is stable. She's working. She's doing the things she needs to do. Let's get out of her life and let her move forward. Okay? Does that make sense?
Yes, sir.
All right. Mr. Peeples, anything else from the state?
No, Judge.
Anything else, Ms. Sherry Lassiter?
No, Your Honor, thank you.
So I have one more thing for you, Ms. Smart. I'm going to introduce you to Ms. Simpson. She's seated in the jury box right there. She's with probation. She is not going to be your probation officer, but she's going to give you reporting instructions. Because you live in Stone Mountain, you'll be supervised in DeKalb County. So Ms. Simpson's going to tell you where you need to be and when you need to be for that first meeting with a probation officer. Make sure you make that first appointment. That's the most important one. That's how we kick things off in the right direction, okay?
Okay.
All right. Ms. Sherry Lassiter, if you join them, I'd appreciate that.
I will.
Once Ms. Simpson's finished with Ms. Smart, both of you are free to go.
Thank you, Your Honor.
Thank you for your help with this case.
Thank you, Judge.
Thank you, Mr. Peeples.